Hello viewers, welcome to another lesson. Today we're going to focus on English law and its application as a source of law in Sierra Leone. Now the question whether a particular rule is also a legal rule can have a large practical importance because the answer may determine whether the rules may be enforced by state organs. Lawyers have developed a number of standards to determine whether a rule has the status of law, and these standards are known as sources of law. Today, we are going to isolate this presentation to one particular source of law, which has shaped the general outlook of Sierra Leone's legal system. In other words, we'll be examining the legal justification for applying English laws within Sierra Leonean jurisdiction. English law as a source of law in Sierra Leone is the main topic for today's discussion. There are two types of laws practiced in Sierra Leone that were completely borrowed from England. First, we have the English common law and some English statutes, which can further be divided into statutes of general application and imperial statutes. The English common law and statutes of general application, which also mean borrowed statutes, acquired status as sources of law in Sierra Leone as a result of two legal important documents. Section 74 of the Court Act 1965 provides that, subject to the provision of the Constitution and any other enactment, the common law, the doctrine of equity, and statute of general application in force in England on the 1st of January 1880 shall be enforced in Sierra Leone. This provision is very important. It sets the stage for the application of English common law, the doctrine of equity, and statute of general application that were promulgated or were found or enacted in England before 1880. Under Section 170, subsection 1, paragraph E, the common law is listed as a source of law applicable in Sierra Leone. I'll give you examples of statutes of general application. The other name of statute, of course, would be Acts of Parliaments or laws made by parliaments. So these statutes, for example, we have the Wills Act 1837 and Statute of Fraud Act 1667. Now, the statutes of general application are quite different from imperial statutes. Examples of imperial statutes include the Lesson Act 1916 and the Perjury Act 1911, etc. Now, statutes of general application are statutes which came before 1880. Statutes of general application, as the name implies, are statutes that were enforced in England that are now applicable in Sierra Leone. Imperial statutes, on the other hand, are statutes that came after the reception dates, that was the 1st January in 1880. They are applicable in Sierra Leone as a result of the Adoption Act. So they were adopted after 1880. What is common law? The common law can simply be defined as a body of judicial decisions that have passed on through doctrine of judicial precedent. This process depends on the hierarchy of the courts and operates in such a way that generally a court is bound by the ratio or rule of law implicit in the decision of a court above it in the hierarchy, and usually by a court of equal standing in the hierarchy. Where a statute does not cover a particular area or where the law is silent, it will generally be necessary for a court to decide on cases relating to such an area to determine what the law is. And in so doing, the court will inescapably and unarguably be creating law. Now, the scope for judicial creativity should not be underestimated, and it should be remembered that the task of interpreting the actual meaning of legislation falls to the judiciary, and thus provides the judiciary with a further important area of discretionary creativity. As the highest court of the land, the Supreme Court has particular scope for creating or extending the common law. And a relatively contemporary example of it adopting such a stance in which it stated that the president can sack his vice president in the case of San Sumana against Attorney General and Victor Fo, 2015. Now, the impact of colonialism in Sierra Leone's legal system. Now, the repatriation of the early settlers in 1787 led to the introduction of English common law through the temporary regulations drafted by Gravin Sharp. That's just the historical significance. We now have the common law. We can trace, the introduction of the common law, the adoption of common law, through the repatriation of the early settlers in 1787. But of particular importance was the document that was drafted by Gravin Sharp, which is referred to as a temporary regulation. In subsequent lesson, we'll be examining other sources of law, like domestic statutes and decisions that were made locally by our courts. Don't forget to subscribe and hit the like button. Thank you.